17. The executor's authority, standing as the living principal over the estate. 1. The estate you never knew you had. Every birth creates an estate, a trust with assets, liabilities, and an appointed representative. The problem is, no one tells you that you were supposed to be the executor. The state simply steps in, claiming administrative control over your legal fiction until you speak otherwise. So what does that actually mean? It means silence left your life in probate. Your estate includes everything attached to your name, property, contracts, taxes, and even your court cases. When you step forward as executor, you reclaim jurisdiction over all those instruments. You don't fight the system, you administer it. Footnote. Legal estates created at birth remain under administrative control until a living executor asserts authority and reclaims fiduciary rights. 2. Letters of office, declaring your capacity. In trust law, everything depends on capacity. The executor's first duty is to declare it. A simple statement, "I am the living executor for this estate," changes the dynamic entirely. The court can no longer presume incompetence or default. So what does that actually mean? It means you've just walked into the boardroom instead of the confession booth. The executor doesn't beg or argue. They instruct. They handle assets, authorize settlements, and ensure that all public actors, including judges and clerks, perform within their delegated authority. Footnote. Proper declaration of capacity converts presumed wardship into active administration, compelling public officials to operate as subordinate trustees. 3. The executor's duty, settlement and closure. The role isn't symbolic, it's accounting. The executor's task is to balance books, discharge liabilities, and close unfinished estates. When the executor speaks, the record corrects itself. The trick is precision, words that create no controversy but all control. So what does that actually mean? It means the pen is mightier than the jurisdiction. When you issue lawful orders, notices, and instructions under executor authority, you act from the top of the hierarchy. Everyone else, trustee, agent, or attorney, must perform accordingly. You're not in their system, they're in your administration. Footnote. Executor actions carry binding authority over subordinate fiduciaries, transforming disputes into administrative resolutions. 4. Living versus legal, the two yous. The executor learns early that two versions of you exist, the living being and the legal entity. The court deals with the entity, the executor manages both. The key is not to destroy the fiction but to direct it. It's your shadow, make it work for you. So what does that actually mean? It means you stop identifying with the puppet and start pulling the strings. Once the living principle controls the estate, law transforms from punishment into policy. The executor no longer reacts, they reconcile. They no longer plead, they instruct. And in that shift, the system quietly bows. Footnote. Recognition of the living principle's authority subordinates the legal fiction, enabling administration instead of submission.